Princess Diana's final wishes weren't carried out exactly as she wrote them. After her death, the document that determined what Prince William and Prince Harry would inherit and when they could receive it was legally changed through the courts. For years, almost nobody knew those changes had been made, making this one of the least discussed chapters in the story of Diana's legacy. It was changed after she died, in secret, through the courts. And nobody told the godchildren's parents it was happening. That's not speculation, that's the paper trail. And the paper trail is where this story actually gets interesting, because it isn't really about money. It's about who controls a legacy once the person who built it is gone, and how quietly that control can shift without anyone outside a courtroom ever finding out. Here's where it starts. On June the 1st, 1993, Diana, Princess of Wales, signed her last will and testament. She was still married to Charles at the time, still years away from the divorce, still years away from August 1997. That will named her 2 sons as the primary beneficiaries. It also named 17 godchildren and her longtime butler, Paul Burrell, among those who would receive something when she was gone. In 1996, a year before her death, she added a codicil, a formal amendment, updating parts of the plan. That was the last version of Diana's wishes that she personally signed. Then, on August 31st, 1997, everything changed. Diana died in Paris following the car crash that shocked the world, and from that moment onward, she no longer had any control over the document she had carefully prepared. Like every will, it ceased to be a set of personal instructions and became a legal instrument to be administered by others. Whatever Diana had intended, whatever conversations she may have had while she was alive, the responsibility for carrying those wishes into reality now rested entirely with the people she had chosen to act on her behalf. Those people were not Prince William, they were not King Charles, they were not Buckingham Palace or any royal official. Instead, the responsibility passed to 2 members of Diana's own family, her mother, Frances Shan Kidd, and her sister, Lady Sarah McCorquodale. Named as executors of the estate, they became the individuals legally responsible for gathering Diana's assets, settling any outstanding liabilities, dealing with the probate process, and ensuring that her estate was distributed according to the law and the terms of her will. That distinction matters more than many people realize. Executors do not become the owners of an estate, nor are they free to ignore the wishes contained in a will. Their role is to administer the estate in accordance with the law while making countless practical decisions that inevitably arise after someone's death. They become the legal bridge between the wishes of the deceased and the reality of carrying those wishes into effect. In Diana's case, that placed an extraordinary responsibility on 2 women from the Spencer family, who suddenly found themselves managing one of the most scrutinized estates in modern history while the entire world watched. The fact that neither Prince William nor Prince Harry played any role in those decisions was entirely predictable. At the time of their mother's death, William was only 15 years old and Harry just 12. They were grieving children, not legal decision makers. Charles, meanwhile, had no authority over Diana's estate simply because he had once been her husband. Their divorce had been finalized the previous year, and the administration of her will rested entirely with the executors she had personally appointed. In other words, from the moment Diana died, the future of her estate was no longer in the hands of the royal family. It was in the hands of 2 members of the Spencer family, acting under the supervision of the probate court and bound by the legal responsibilities that come with administering a will. That decision would shape everything that happened next. And here's the first thing worth sitting with. The estate itself was not small. Probate filings placed Diana's assets at around £21 million, roughly £70 million after inheritance tax was paid. In today's money, that number is significantly larger. This wasn't a modest personal account. This was a fortune, sitting in trust, waiting for 2 boys who were 15 and 12 years old and legally incapable of receiving any of it directly. So the will did what wills for minors typically do. It placed everything into trust, split evenly between William and Harry, to be released when they reached a certain age. And this is where the story stops being simple, because the original 1993 will said 25. That was the age Diana chose while she was alive. 25. Old enough to be trusted with serious money, young enough that she'd still, in her mind, likely be around to guide them through it. She wrote that will as a mother who expected to be there. She wasn't there, and that changed everything about how that number got treated. Here's what happened next, and it's the part almost nobody talks about. After Diana's death, the administration of her estate did not simply proceed exactly as she had written it. Instead, her executors applied to the probate court for what is known as a variation, a formal legal process that allows certain terms of a will or trust arrangement to be altered with judicial approval after the person who made the will has died. This wasn't an informal family agreement or a private understanding reached behind closed doors. It was a recognized legal procedure considered by a judge and approved through the courts, and in this case, the application succeeded. The most significant change involved the age at which Prince William and Prince Harry would receive full control of their inheritance. Under the revised arrangements, the age was increased from 25 to 30. That meant William did not gain unrestricted access to his share until 2012, while Harry had to wait until 2014. On paper, it's easy to describe that as a simple amendment to the trust. In reality, it represented a substantial change to the timetable Diana had originally left behind. 5 additional years is not an insignificant delay, particularly when dealing with an estate worth millions of pounds. Supporters of the decision argued that the change was sensible. Large inheritances are often structured to protect younger beneficiaries from receiving enormous wealth before they have gained sufficient maturity and life experience. Delaying full control until the age of 30 could be seen as a cautious, responsible measure designed to safeguard William and Harry's long-term interests rather than limit their independence. From a legal and financial perspective, there were reasonable arguments for making the adjustment. But there is another way to look at it. Whatever the reasoning, the outcome remained the same. 2 boys who had already experienced the unimaginable loss of their mother found that the timetable she had originally established for her final gift to them no longer applied. The new terms were not ones Diana had personally signed. They were approved after her death through a court process initiated by those responsible for administering her estate. The law permitted it, the judge authorized it, and the revised arrangement became legally binding. Yet the practical effect was unmistakable. Instead of receiving full control of what their mother had left them at 25, William and Harry each waited another 5 years under conditions that had been determined not by Diana herself, but by a court acting on the recommendation of her executors. For an estate so closely associated with one of the most famous women in the world, that quiet legal revision remains one of the least discussed chapters in the story of Princess Diana's final wishes. And the changes didn't end with William and Harry's inheritance. The court-approved variation also altered another part of Diana's original wishes that receives far less attention: the gifts intended for her godchildren. In the arrangements she had originally put in place, each godchild was to receive a portion of her personal property after her estate had been administered. It was a meaningful gesture reflecting the close relationships Diana had maintained with the people she had chosen to play an important role in her sons' lives. Rather than leaving them as an afterthought, she had specifically included them among the beneficiaries of her personal belongings. The revised terms changed that arrangement as well. Instead of each godchild receiving a share of the personal property as originally envisioned, the distribution was simplified. Each would receive a single item selected for them from Diana's possessions rather than a broader share of the collection. The practical value of those gifts would naturally depend on the individual item, but the principle had changed. The original concept of sharing part of her personal estate gave way to the presentation of one carefully chosen keepsake for each godchild. From an administrative standpoint, the revision made the estate considerably easier to manage. Dividing a large collection of personal possessions among numerous beneficiaries can become complicated, particularly when many items have sentimental rather than obvious financial value. Allowing each godchild to receive one meaningful object reduced the likelihood of disputes, simplified the distribution process, and preserved much of the collection for Diana's 2 sons. For the executors, it was a more practical way to administer the estate. Even so, the change illustrates the broader pattern running through the entire variation. It wasn't simply the age at which William and Harry would inherit that was adjusted. Other provisions of Diana's estate were also rewritten after her death through the legal process. Every change may have had a practical justification, and everyone was approved by the court, but taken together, they reveal something many people never realize. The final distribution of Diana's estate did not unfold exactly as she had originally written it. The legal framework she left behind was modified by those responsible for administering it, with the court's approval, meaning that several of her final wishes were ultimately carried out in a different form than the one she personally signed. Here's the detail that makes this genuinely uncomfortable. None of this was announced. The parents of those godchildren, the people who would have had every reason to want a say in decisions affecting their own children's inheritance, were not notified while the court process was happening. This wasn't debated in public, it wasn't reported at the time. It sat quietly in probate filings, and it took years before anyone outside the legal process understood that Diana's actual signed wishes had been altered before her sons ever collected a shilling. So that leads to an obvious question: whose decision was it really? Legally, the application came from Diana's executors, acting with the support of Francis Shan Kidd and Lady Sarah McCorquodale. They were entirely within their rights to ask the court to vary the trust arrangements, and there were sensible arguments behind doing so. William and Harry had lost their mother as teenagers, and inheriting millions of pounds at the age of 25 could reasonably be seen as a heavy responsibility for two young men still finding their place in the world. Delaying full access until the age of 30 could be presented as a safeguard rather than a restriction, an attempt to give them greater maturity, more life experience, and stronger financial judgment before receiving the entirety of their inheritance. Viewed from that perspective, the decision can be understood as a protective measure rather than an attempt to overrule Diana's intentions. Executors and trustees often have a legal duty to consider the long-term interests of beneficiaries, particularly when large estates and relatively young heirs are involved. The court's approval also meant the change was made through a lawful constitutional process rather than by private agreement behind closed doors. But the way the story is framed depends entirely on which part you emphasize. Whatever the motivation, the practical result did not change. The financial arrangements that Diana had originally put in place were altered after her death. The new timetable was not something she personally signed or approved because she no longer had the opportunity to do so. Instead, it was authorized by a court after hearing the recommendations of the people responsible for administering her estate. That creates an uncomfortable reality. Two young princes, still grieving the loss of their mother, ultimately received their inheritance under terms that were different from those she had personally left behind. Whether those revisions were wise, necessary, or entirely justified is open to debate. The legal process itself was perfectly legitimate, yet it also illustrates an unavoidable truth about wills and estates. Once someone dies, the administration of their wishes inevitably passes into the hands of the living. And in this case, the final version of Diana's estate reflected not only what she had written, but also what others later persuaded the court was in her son's best interests. Now follow the money forward, because this is where it gets even more specific. While the trust was held, it wasn't sitting idle. It was managed conservatively. No aggressive investment, no attempt to grow it aggressively, just steady, careful stewardship, designed to preserve capital rather than chase returns. And it worked, in the quiet way trust management is supposed to work. By the time William turned 30 in June 2012 and Harry turned 30 in September 2014, each of their original shares, which started at roughly £6.5 million apiece after the estate was split and taxed, had grown to somewhere around £10 million each. Not explosive growth, not the kind of number that makes headlines. Just 15 years of patient, unglamorous trust management doing exactly what it was designed to do. But here's what's easy to miss in all of this. That growth happened entirely outside William and Harry's control. They couldn't touch the principal. They could, from age 25 onward, access some of the interest the trust generated. A partial concession, a middle step between nothing and everything. But the actual capital, the £10 million each, stayed locked until 30. Two men who were already adults, already serving in the military, already public figures with responsibilities most people twice their age never carry, still had to wait for a court-ordered age threshold before they controlled money that was, legally and unambiguously, already theirs. And then there's the part of the estate that had nothing to do with numbers at all. Diana's wedding dress, the famous ivory silk taffeta gown with its extraordinary 25-foot train, still the longest ever worn at a British royal wedding, was one of the few possessions singled out by name in her estate. By the time of her death in 1997, it had already become far more than a piece of clothing. It was one of the most recognizable garments of the 20th century, instantly associated with the fairy tale wedding that captivated hundreds of millions of viewers around the world. Diana clearly understood its historical significance, which is why she made specific arrangements for its future rather than allowing it to be absorbed into the rest of her personal belongings. Many people assume the dress passed directly to Prince William and Prince Harry after their mother's death, but that isn't what happened. Although they were the ultimate beneficiaries, the gown did not immediately become part of their personal possessions. Instead, it remained under professional care and was exhibited publicly for years, allowing millions of people to continue viewing one of the defining symbols of Diana's life and legacy. Rather than being locked away in a private collection, the dress continued to serve as a piece of royal history, appearing in exhibitions that celebrated Diana's life and charitable work. Only when Prince Harry reached the age of 30 did the dress formally pass into the joint possession of Diana's two sons, in accordance with the arrangements governing her estate. By then, both William and Harry were adults, with established public roles, making them the legal custodians of one of the monarchy's most iconic historical artifacts, rather than simply two young princes inheriting their mother's wardrobe. The same general approach applied to much of Diana's personal jewelry. While a number of her most famous pieces have since become closely associated with Catherine, Princess of Wales, and the Duchess of Sussex, many items were not individually listed in Diana's will. Instead, they formed part of her personal effects and were divided between William and Harry as personal property, rather than requiring every bracelet, necklace, or pair of earrings to be separately itemized and formally valued within the estate. Many of these belongings were treated as ordinary personal possessions to be distributed to her beneficiaries. That gave the brothers flexibility over how the collection would ultimately be shared and preserved. Years later, several of those pieces would reappear in public, worn by the women who married Diana's sons, allowing small parts of her personal legacy to remain visible within the royal family long after her death. This is where the story becomes genuinely emotional rather than just financial, because those jewelry pieces didn't stay in a vault, they moved into real life. William gave Diana's engagement ring, the sapphire and diamond ring that has since become one of the most recognized pieces of jewelry in the world, to Kate when he proposed. Harry, who had chosen to keep the ring himself for years after Diana's death, made the decision to hand it over to his brother, believing it belonged on the hand of a future queen rather than sitting in a drawer. When Harry later proposed to Meghan, he didn't ask for the ring back. He designed something new instead, using diamonds pulled from his mother's personal collection so that Diana was present in the moment in her own way, without repeating what had already been given to William. That's not a detail from a court filing. That's two brothers quietly making their own decisions about their mother's memory, independent of trustees, independent of the palace, independent of anyone's permission. And it's arguably the most honest part of the entire inheritance story because it's the one part where William and Harry actually got to choose. But there's one more piece of this that most people assume is true and isn't, and it might be the most revealing detail in the whole story. People assume William and Harry will one day inherit Althorp, the Spencer family's ancestral estate, the 900-year-old home where Diana grew up, where she is buried on the small island in the middle of the Oval Lake. It feels like it should belong to them, at least eventually. It doesn't, and it never will. Althorp passes through the Spencer family under primogeniture, the same rule that for centuries determined that titles and estates moved to the eldest male heir. Diana's father inherited the earldom and the estate in 1975. When the current Earl Spencer, Diana's brother Charles, eventually passes the title on, it goes to his son, Louis Spencer, Viscount Althorp, William and Harry's first cousin, not to William, not to Harry, regardless of the fact that Louis has 3 older sisters. The rule doesn't bend for closeness to Diana. It doesn't bend for the fact that William is heir to the throne of England while Louis is not. It follows the male line of the Spencer name, full stop. So William and Harry can visit their mother's grave. They can come and go from Althorp privately whenever they choose. That access has never been in question. But the house itself, the place that shaped who Diana was before she ever became a princess, will never legally belong to either of them. It was never part of their inheritance to begin with, and no court variance, no family negotiation, no royal title changes that. It sits entirely outside the 2 men who are, in every meaningful emotional sense, Diana's legacy. Put all of this together and you start to see the actual shape of the story, and it's not the shape most people expect. This was never really a story about William and Harry receiving a fortune. It's a story about how much of what belongs to you can still be controlled by other people, even after the person who intended to give it to you is gone. Diana wrote a will that said 25. A court, acting on her family's request, said 30. Diana wanted her sons and godchildren to receive shares of her belongings. A variance, filed without public notice, reduced that to single items. Diana grew up at Althorp. Her sons never will own so much as a room of it, because a rule older than any of them decides who gets to hold that name. And maybe that's the real reason the wedding dress mattered so much, and the ring and the jewelry passed hand to hand between brothers, making their own private decisions about how to honor her. Those were the only parts of this entire estate that weren't dictated by a court, a trustee, or a centuries-old rule of succession. Everything else about Diana's inheritance was decided, delayed, or redirected by someone other than her. The wedding dress and the ring were the one place where William and Harry actually got to decide what their mother's memory meant on their own terms, without asking anyone's permission first. That's the quiet irony sitting underneath this whole story. A princess who spent her life pushing against an institution that tried to control every part of how she lived, ended up leaving behind a will that institution, through family, through courts, through legal process, still found ways to reshape after she was gone. The money eventually arrived, the dress eventually arrived, the ring changed hands twice, each time by choice rather than obligation. But it took 15 years, a secret court filing, and the quiet cooperation of the 2 family members closest to her to get there. And somewhere in that gap between what Diana actually wrote in 1993 and what her sons actually received by 2014, there's a simple truth that outlives every headline about royal money. Leaving something behind and having it arrive exactly as you intended are 2 very different things. Diana managed the first. The second was never fully in her control, not in life, and, as it turned out, not after it either.